Many thanks, Bruno. Let me start by expressing my gratitude for the invitation. Allegedly, Christine Lagarde, the president of the IMF, once threatened to leave a meeting if anyone mentioned the German Bundesverfassungsgericht once again. She wanted to have political and economic debates on the euro crisis, no lecture on German constitutional law. If you share her conviction, you would have to leave the room now. I will do the same. Unfortunately, I won't leave, but I will have to discuss the German position, because if you discuss national constitutional limits to the euro crisis, everyone does, of course, look at and consider the German perspective. I don't have a PowerPoint, but I do have a clear structure. First, the context. Second, the doctrinal constitutional background. Third, the recent ESM ruling. Fourth, its implications. And fifth, the role of European law. Let me start with the context. From a domestic German position, the Constitutional Court is in a somewhat paradoxical situation. On the one hand, it is an integral part of German political establishment. At the moment, no less than 50% of the bench, 8 out of 16 judges, are public law professors, university professors like myself. And those of you who are familiar with German legal scholarship know that most of us prefer sound doctrinal arguments to critical legal studies. We are, generally speaking, politically rather mainstream and tend to support government policies. In short, we are German public law professors, much more than our colleagues in other member states and the US, part of the political establishment. But when it comes to the euro crisis, the German Constitutional Court is paradoxically perceived as an anti-establishment institution by the general public. There was an opinion poll last summer, and it showed that the court is, within Germany, the most trusted institution. Its support rate stands at 75%, 75% for the court, compared to 40% for the national parliament and government, 22% for the European Commission, and 17% for political parties. The situation was quite different a decade ago. And arguably, the increase of popularity on the side of the court has to do with its critical standpoint on Europe. In the same opinion poll, the citizens were asked whether they wanted to take politicians to take the lead. And 80% of the citizens said, no, we want the court to have the final say. Generally speaking, German public opinion, German citizens are quite happy with the court being the ultimate arbiter. And this is no coincidence. As most of you may know, within the German political establishment, a pro-European consensus prevails. And as a result, Eurosceptics had to turn to the court for critical positions and reflection. You may say that the Bundesverfassungsgericht serves as a lightning rod, giving a voice to discomfort with deeper integration, which is not always adequately represented in the German domestic debate. Ever since the Maastricht Treaty, things developed along similar lines. First, Parliament approves new integration measures by an overwhelming majority of around 90%. Critical positions and critical voices are then voiced by the court only. It's probably correct to say that within Germany, court judgments assume the role of referenda in other member states. That's the context. Second, the doctrinal constitutional foundations of the German case law. External observers are not always aware that the court has developed two distinct limits for further integration. First, the traditional notion of ultra vires, and second, constitutional identity review. The innovation of the latter, constitutional identity, is best illustrated by a comparison between the German Lisbon judgment and the earlier Maastricht decision. While Maastricht was primarily about the democracy-rooted defense of the principle of conferral, attributed powers, Lisbon concentrates on the sovereignty-based defense of sovereign statehood. And this shift of emphasis on the side of the courts from the principle of conferral to sovereignty pervades all its recent judgments. In the Lisbon judgment, the court proclaimed, without further explanation, that Germany's post-war constitution prohibits a federal Europe. As a result, any treaty change which in the eyes of the court crosses the threshold of European statehood, exceeds the powers of the German parliament. Instead, you would have to activate the ultimate sovereign, the people, which in practical terms would require a referendum. Only the German people may authorize treaty reform, which in the eyes of the court crosses the red lines defining German sovereignty. That's of course very abstract, so the court needs more specific criteria to apply in specific cases. And as mentioned a minute ago, we need to distinguish ultra-virus and identity control. First, ultra-virus. Ultra-virus is in essence, as most of you may know, about the principle of referral. The court famously claims that it has ultimate jurisdiction about the scope of EU powers. The underlying constitutional argument is simple. Powers are transferred on the basis of an act of parliament, which metaphorically speaking serves as a bridge for the domestic application of European law. Ultra-virus acts, which do not respect the limits of attributed powers, are denied entry into the domestic German legal order. When it comes to such arguments about ultra-virus, the court very much softened its position in a decision of 2010 on age discrimination. And this conciliatory approach to ultra-virus is quite relevant for our topic. Why? If Karlsruhe proceeds with a review of the ECB's bond purchases, it would do so on the basis of ultra-virus. I'll come back to this later. By contrast, the recent judgment on Euro rescue operations, on financial support for other member states, follow a different logic. They are not about ultra-virus, they are about constitutional identity. And what is this identity review about? Respect for constitutional identity constitutes an autonomous country-specific standard whose content is defined by the German constitution alone. In the German context, it's based on the so-called eternity clause, Article 79, paragraph 3 of the Constitution, which declares that the principles of democracy, the rule of law, human dignity, and also federalism may not be affected by constitutional amendment. This eternity clause, which was originally conceived and introduced as a safeguard against Nazi or communist dictatorship, was repositioned against European integration by the court in the Lisbon judgment. It is important to understand that when it comes to EU integration, identity review is in essence about the interpretation and meaning of one word alone: democracy within the context of the sovereign nation state. You don't need judo, you have the European Constitutional Court, which interprets and explains what democracy in our age means and is about. And this level of abstraction, developing a whole line of case law out of the simple word democracy, is a problem in itself for the court's authority. Why? Among German public lawyers, doctrinal arguments remain influential, yet any judicial declaration about the state and limit of democracy in our age is inherently vague. There are few, if any, doctrinal standards which the court may activate. It has to improvise. What did it do? In order to render the democracy yardstick justiciable in individual cases, the court proclaimed, without much explanation, core areas of state competence. In the eyes of the court, criminal and family law, social policy, or military missions are covered by a democratic domaine réservé. In these areas, the German constitution is set to prohibit the extensive transfer of competences to the European level. Not any European action is declared unconstitutional. Instead, the Bundestag must remain room for maneuver in these policy fields. Against this background, we have and may identify the crucial constitutional limit for the deepening of economic and monetary union. All supra and international treaties which abolish budgetary autonomy, which limit extensively the autonomy of the Bundestag in these policy fields, would violate the eternity clause. Only the people, the German people, could authorize such a move towards European statehood. My third section, the ESM ruling. As most of you know, the Bundesverfassungsgericht rendered its much-awaited decision on the European Stability Mechanism in September this year. From a procedural perspective, it's an interim order only, but the court states explicitly that this interim evaluation is based on a more or less final decision on the constitutional, the compatibility of the ESM from the perspective of identity review. By contrast, the bond purchases have not yet been evaluated. What then is the court's position on constitutional identity? As mentioned a minute ago, the court assumes that the preservation of democracy at national level guides the identification of a democratic domaine réservé. Taboo zones for further integration include budgetary matters. In the words of the court, there is a violation if the German Bundestag relinquishes its budgetary responsibility. The German Bundestag may not, even by statute, subordinate itself to any mechanism which may result in incalculable financial burdens. On this basis, which the court considers to be a deduction from the word democracy in the eternity clause, the court establishes two precise conditions for German participation in rescue operations. One is procedural and the other substantive. First, the procedure. The court requires German national parliamentary consent to financial assistance on a case-by-case basis. The Bundestag may not sanction the ESM treaty and its implementation in one single vote. It rather needs to give its consent to each rescue operation individually. Otherwise put, the court obliges the government to go back to Parliament whenever the ESM sets up a new program or changes an existing scheme. That is one of the reasons why the German government at the moment tries to delay any decision on Greece, because it tries to evade another parliamentary vote. That's the procedure. Second, the court had indicated in an earlier ruling of last year on bilateral loans to Greece that there may be absolute limits to which Germany, absolute limits of the amount of money to which Germany might sign up to. And this provided critics with ample ammunition against the ESM. At the time when the court indicated that there may be absolute limits, everything that was at stake was bilateral loans to Greece, which entailed a financial risk for Germany of a meager 22 billion euros. By contrast, overall German liability for the ESM and the EFSF, excluding Target 2, add up to in between 200 and 300 billion euros, depending on how you calculate. That's 10 times more than the initial loans to Greece. If the latter resulted in a principled warning on the side of the court, it was no far-fetched assumption that the new ruling on the ESM treaty would go further. Indeed, critics were emboldened before the ruling last September by newspaper interviews which were given by the Chief Justice Andreas Voskuhle and the reporting judge Peter Huber, two public law professors, who seemed to indicate that a referendum on a new German constitution was imminent. There was a widespread assumption also among German constitutionalists that the court would at best clear the ESM with strict caveats, including red lines for overall liability, and move towards fiscal union. Things turned out differently. However, last September, the idea of justiciable maximum limits is effectively abandoned. The court explicitly leaves undecided whether such limits exist at all. In any case, it would only intervene in extreme scenarios. Regular circumstances are subject to a broad parliamentary margin of appreciation. 1 year earlier, the soundbite had been quite different. Once again, the German Constitutional Court barked initially, but shied away from biting later. The two remaining caveats which the court required for the entry into force of the ESM treaties are more or less a consolation prize for the plaintiffs. It said the overall amount of German liability has to be fixed at 190 billion euros, but we should be careful not to misread that as a maximum, an absolute limit. On the contrary, the court states explicitly last September that further financial support is possible under one condition: the German Bundestag needs to give its consent. In a nutshell, the core message reads: rescue operations may proceed if the German parliament approves them on a case-by-case basis. I personally think that's the correct answer. Otherwise, it would quite simply be impossible. It would overstretch the possibilities of hermeneutical interpretation to deduct more limits from the principle of democracy. Fourth, the implications. The softening of the court's position is important, but it should not distract us from existing implications which exist nonetheless. Since budgetary powers fall within the democratic domain réservé, the German parliament must remain the place where core decisions on budgetary matters are taken. That does not render treaty reform impossible, but presents negotiators with stumbling blocks. A first victim is evident. We may consider small-scale debt mutualization, such as short-term euro bills, or even a watered-down version of long-term euro bonds with annual parliamentary consent. But without involvement of the German Bundestag, debt mutualization will not fly. And the threat of the veto by the German Constitutional Court may be reason enough to embolden existing critics within Germany. Indeed, the Social Democrats and the Greens have quietly shelved their initial support for Eurobonds in the light of constitutional difficulties and public opinions. In the medium run, implications may even be more far-reaching. Why? The Bundesverfassungsgericht has a broad understanding of the democratic domain réservé. The Lisbon judgment emphasizes that besides budgetary matters, also fiscal policy, and that means tax issues, as well as economic and social policies, must, as a matter of principle, remain in the hands of the Bundestag. These limitations did not feature prominently in the judgments on Greece and the ESM for the simple reason that the court was only asked to rule on financial assistance. These limitations will surface, however, if substantive treaty change moves ahead. I personally assume that the court would follow a similar line as on financial assistance. The overall degree of cooperation, that means the degree of treaty change, would be left to politicians to decide on the basis of a margin of appreciation. Karlsruhe will insist, however, that the Bundestag remains the primary locus for decision-making on taxes, the economy, and social policy. Let me be clear, I do not expect the court to veto any forthcoming treaty change, yet it remains a veto player and will insist upon a central role for the Bundestag. And this leads me to a general remark on institutional design. If the German Bundestag remains the primary forum for decision-making on budgetary issues, taxes, the economy, social and economic policies, the Bundesverfassungsgericht effectively prescribes an intergovernmental approach marginalizing the European Parliament. That may be done within the EU treaty or outside it, but the Bundesverfassungsgericht, I fully agree with everything Bruno said, but the Bundesverfassungsgericht is the only player who actually pursues a strategic plot of intergovernmentalism. Fully fledged supranationalization of economic and social policies would encroach upon the democratic domain réservé and violate the German constitution. It would cross the Rubicon of European statehood in the eyes of the court, and only the people could authorize such a move. And this fits neatly with the court's utterly negative approach to the European Parliament in the Lisbon judgment, in which it had presented the expansion of direct democracy through the European Parliament as a latent threat to democratic sovereignty, to the democratic sovereignty of the member states. At the time of the Lisbon judgment, this appeared as a rather abstract statement, a more or less academic proclamation. Remember that half of the judges are public law professors. Unfortunately, however, the court has started in the meantime to translate the theoretical demolition of the European Parliament into tangible consequences. First, as some of you might have heard, it annulled the 5% hurdle for European elections in Germany, arguing that the European Parliament is no real parliament and that therefore there is no need for a 5% hurdle which protects effective functioning of parliamentary decision-making. And this is not a mere technicality. It means that fringe parties will enter the parliament since Germany has 96 votes. So 1% is enough for a seat. The court's analytical denunciation of the EP turns into a self-fulfilling prophecy. And second, the court cements the power of the national legislature. As mentioned a minute ago, the concept of democratic domaine réservé implies that the Bundestag must remain the primary decision-making forum on budgetary matters, social and economic policies, while the European Parliament remains a bystander. And this has implications. The direct political implications are limited. Most political parties within Germany continue to support the ESM Treaty. Merkel has won every vote due to opposition support. There is no danger of a direct political veto from Berlin. Yet, such votes in the parliament are not a procedural nuisance only. They affect the fabric of German society. What do I mean? Media attention on such occasions is massive, much, much more than the European Parliament could ever dream of. Adrien Héritier mentioned the institutional changes at European level. Speaking to my students and even my colleagues, public law professors or private law professors, most of them have never heard of these changes. They're totally unaware of it. But every German citizen knows that the Bundestag votes on the rescue operation and that the Bundesverfassungsgericht will rule upon them. These court judgments and these parliamentary votes on European affairs are political practices which bring about the discursive strengthening of national identity. They are building blocks for a Germany reimagining itself as a political community. 10 years ago, I would have thought that a crisis such as the current one would be a catalyst for pan-European debate, the hour of birth, if you want, of a Europe as a political community. But from a domestic German perspective, at least, the Lisbon judgment turned out to be a self-fulfilling prophecy. Its core motivation, the strategy of the court, has always been to buttress the nation-state and its democratic credential, and it seems to me that, at least for the moment, it is quite successful. This brings me to my last section, European law. You certainly noticed that I have so far concentrated on national constitutional law. And indeed, the Bundesverfassungsgericht does the same. It willfully evaded to analyze rescue operations from the perspective of EU law. Although the plaintiffs had argued on both occasions that the ESM Treaty and bilateral loans to Greece violate Article 125 TFEU. In contrast to the Irish Supreme Court, the Bundesverfassungsgericht ignored these claims, resolving both cases on the basis of German constitutional law instead. That is no coincidence. As mentioned at the outset, German citizens trust the court more than any other institution. And this arguably reflects and requires the court to be able to reconstruct political and social challenges as a matter of constitutional law. The German constitution serves as a microcosm for the resolution of political and social problems. And this aura of the court, which underlies its standing within Germany, would be severely damaged if the German Constitutional Court was dethroned in the eyes of the public. It's one thing for the court to pronounce with great fanfare that the ESM Treaty is compatible with the Constitution under the condition that the government insists upon an interpretative declaration safeguarding the German national interest as it did 2 months ago. But it's quite another thing to say that A, the ESM Treaty is compatible with the Constitution, and B, compatibility with the EU Treaty must be decided in Luxembourg. That's not what citizens expect from the court, although that is what, in my view, the court should have done. Fortunately, I may conclude on a positive note. As indicated earlier, the German Constitutional Court has so far not ruled on the legality of the ECB's bond purchases. The interim order states explicitly that the OMT program will be dealt with at a later point. And this leads me to my final comments. Scrutiny of the bond purchases will require the court to switch from identity review to ultra-virus control. And with regard to the latter, the court had emphasized on an earlier occasion that ultra-virus control will always be based upon the prior consultation of the Court of Justice. It will be virtually impossible for the court to climb down from this commitment. I would therefore not be surprised if a first reference from Karlsruhe would be imminent. It is true that Karlsruhe would retain the last word. It may conclude that Luxembourg's interpretation of Article 123 is manifestly wrong and constitutes an ultra-virus act. But to have the last word is something totally different from having the only word. And that is what the Constitutional Court did so far. It was the only court which in the eyes of the German public spoke. I personally do not expect, my personal prediction would be that we have a reference, but that the reference that we have a reference, but that at the end of the day, the German Constitutional Court does not find an ultra-virus act. And I will briefly explain so with three final comments. First, the court indicated in the Honeywell decision of 2010 that it is the primary responsibility of the ECJ to interpret EU law. The German constitutional law will not simply state that it is of a different opinion if it finds an ultra-virus review. It will only conclude that we have an ultra-virus act when we have a manifestly wrong judgment, which moreover has a significant impact upon the vertical balance of powers. That's a very high standard which rarely will be met. Second, it is wrong, as some commentators claim, that the court has already declared the bond buying program illegal. All we have is an obiter dictum on a possible banking license for the ESM. An obiter dictum which, by the way, the court does not even consider important enough to translate into English. All it says is that such banking license of the ESM may violate the EU treaties. The core sentence reads, bond purchases by the ECB on the secondary market which aim at financing national budgets are prohibited as a circumvention of Article 123. For all I understand, Chiara would not object to this statement. The court does not say that bond purchases are illegal per se. It rather depends on the objective of the program. And the ECB argues, as Chiara has explained, that the bond purchases are necessary to render its monetary policy objective. Third and finally, I do not expect the court, the German Constitutional Court, to contradict a possible conclusion on the side of the ECJ that indeed the ECB action does not violate Article 123. The reason is simple. To do so, to reject the ECB's position would require the court to embark upon a macroeconomic analysis of its own. It would have to say that no, the ECB is wrong in claiming that the bond purchases are necessary to render its monetary policy effective. That I do not see happening. Remember that half of the bench is public law professors who prefer doctrinal arguments to interdisciplinary analysis. My time is up. By way of conclusion, my vision for the future. I very much hope that the Bundesverfassungsgericht refers the bond purchases to Luxembourg. Why? To do so would change legal dynamics, at least within Germany. We would no longer discuss from a domestic German perspective the euro crisis primarily under reference to a national court interpreting the national constitution with a view to strengthening national parliaments. Instead, supranational institutions and supranational law would take center stage. That is, I think, what we need. Thank you.